he is so firmly against what is happening in this court and so firmly for the old America that we know, not this America, that he will take that stand on Monday. He will open himself up to whatever they want because he's not afraid. People that are afraid cower. President Trump doesn't cower. We'll be back on Monday.
Except it appears Donald Trump may have cowered. He did not take the stand today in the months-long New York civil fraud trial against his business. He wrote on his platform, Truth Social, yesterday, quote, "I have very successfully and conclusively testified," and he added that he had nothing more to say. But the New York Times reports that the reasoning behind his about-face by the ex-president may be that he's actually listening to his lawyers. They write, quote, "Two people with knowledge of Mr. Trump's decision said that his legal advisors were concerned that any further testimony would do more harm than good, given that they believe the judge is biased against the former president." While Mr. Trump often believes he can talk himself out of trouble, he appears to have heeded that advice this time. We're back with Andrew and Lisa. Lisa, let's talk about this for a second. What's the connection? I understand all of the stuff that the New York Times reporting, except that line where he said they believe the judge is biased against him. Why would that influence whether or not Donald Trump would speak in his own behalf?
I think because Donald Trump has a version of the story that he wants to tell, and Judge Engoron has not been particularly willing to let Donald Trump just talk ad infinitum, right? And so to the extent that his lawyers are saying to him, hey, this judge is biased against you. The judge said the last time Trump testified, basically, if you don't cabin your speech, I'm entitled to draw negative inferences against you for not shutting up and keeping your answers to the questions that are put before you. It's that sort of situation that is causing the lawyers to say, hey, you might as well stay home. But I really think, Allie, that what's behind that is when he testified the first time, he made a series of admissions that were literally like throwing roses at the Attorney General's office. He said, I reviewed the statements of financial condition. I was the final reviewer of that. At times, I made corrections. At times, those values struck me as too high with respect to my triplex apartment or the Seven Springs property. And I could go on from that trial transcript that day on November 6th of the various things he said that were not helpful to him. So if I'm Chris Kise and Cliff Robert and even Alina Habba, I'm telling the guy, sir, please stay home.
Does any of it matter that he didn't about face, or does it matter that he's not testifying? And does that matter to the outcome of this judgment?
Well, we don't know about the outcome, but here's the thing. He's already testified once. So in terms of a credibility finding, the judge has that ability to do it, whether he testifies once or twice. I totally agree with Lisa that the smart move here was for him not to get back on the stand. I mean, he could only lose. He has said already his story. Whether the judge believes it or not remains to be seen. I agree with Lisa. It's more probably he doesn't believe at least all of it. But, you know, that remains to be seen. But he could only hurt himself. He is not a particularly effective witness. And so if you're the defense, you're saying, I've put on a number of experts. I have called some fact witnesses. Our defense case went well. Why do I want to put on a witness who's a wild card who could take all of that away and give the prosecution, here, the state another opportunity to have at you and to make more headway? Let's sort of end on a strong note. So this was, I think, the right move. I'm not sure if I were his counsel, I would have been on TV talking about, not cowering and all that. Better to have kept a low profile until until Monday and see what happens. But I don't think, again, that's not evidence in the case. That may hurt in terms of public opinion, but ultimately it's really about what's happening in the courtroom. And now it's really for the state to put on a case to see if they can rebut various aspects of what the defense put on, I think, relatively effectively last week.
Generally speaking, Donald Trump thinks anybody who prosecutes him or judges his cases is biased against him. That's not a new allegation. How relevant is that in this case? Because he's gotten into it with the judge a few times.
He's gotten into it with the judge. He's gotten into it about the judge's principal law clerk, which, as you know, is the basis for the gag order that's still in place now and has been enforced against him already twice. I don't think it is relevant in terms of what is actually going on in that courtroom. How relevant is it to his political narrative? Hugely relevant to his political narrative, but not at all a reflection of what's actually happening in that courtroom. Over the last couple of weeks, Allie, you've seen a very different Judge Engoron, who I think has sort of made a determination. I'm going to give these folks as much latitude as I can to present their case without interruption, without making evidentiary rulings, because to the extent that I do rule against them in the end, that's one less thing for them to complain about on appeal.
It is instructive, though, because Judge Engoron is the one we've been watching, but we know that Donald Trump has beef with Judge Chutkan. We know that the judge in Georgia is a charismatic character. He seems to really like his judge in the Mar-a-Lago case. But generally speaking, how instructive is the interaction, the interplay we've seen between Donald Trump and his people and this judge about the other trials that we're going to see?
Well, first, anybody who is viewed as a check on his power is going to be subject to attack. And that's just not a question of judges. It's true of prosecutors. It's true of people in the media. It's true. I mean, it's just, that is just a common thing. It is like, he does not believe in checks and balances. And so that's why this is happening. I do have a note of caution about Judge Engoron, though, which is he found against Donald Trump on the first cause of action. But he correctly said, and it's important to note, that that cause of action did not require a showing of intent. It did not require reliance. It didn't require materiality. And so he said, look, the other causes of action that I am trying now that are the subject of the trial that Lisa's covered so well is something that requires mens rea, intent. It does require materiality. And so, I think I want to wait and see. Judge Engoron seems like a rational, reasonable judge who is applying the law. And so we really have to see what he's going to do with the facts here and say, does he really think that the state has proven by its standard of proof, which admittedly is much lower than a criminal case, but has it shown those additional elements? And I do think it's just because he's found as to the first count, and that obviously carries a lot of weight in terms of what can happen, but it doesn't mean that he's going to find the other counts which have additional elements. And if I were Donald Trump's counsel, I would sort of talk up to the judge in terms of, he's a judge who took an oath of office and I think is going to try to be faithful to it.